Hello friends, I am Dr. Balakrishnan. I am from the National Law School at Cochin. I am an associate professor there. The module that I would be dealing with now is regards the functionaries of criminal justice administration, including the hierarchy of courts. Criminal justice administration involves diverse functionaries who are involved in defining a crime, investigating an offense, and prosecuting the criminals. There are persons who conduct trial and sentence those who are convicted of the offenses that are alleged against them. After the sentencing, there are functionaries who are involved in administering what is called as the post-conviction imprisonment or other steps that are to be resorted to. Therefore, these multiple functionaries come at various stages, starting with investigation, prosecution, trial, and post-conviction. What we would be going through is looking at these functionaries in terms of what their role is, in terms of what functions are assigned to them, and see as to how it could be that they have to perform the roles that are assigned to them, and when it may even constitute an abuse if you are not performing the role that is assigned to you. If we start with the concept of crime, we must understand that every social order designates certain forms of harmful behavior as crimes. Now, this particular definition is generally given by a state in modern societies, because state assumes a pivotal role in the conceptualization of a crime. If you go in search of theories in terms of this conceptualization, there are essentially two theories that stand out. The first one is the consensus theory, which refers to a certain level of consensus among the population, which is reflected in the decision of a sovereign to make an act a crime. The other is what is called as the conflict theory, wherein what you find is that there are conflicts in the society, and whichever is the dominant section in the society ensures that acts that are detrimental to their interest would be classified as crimes. Probably that is what is reflected in the definition of crime as given by Russell in his treatise, where he says that these crimes are basically a creation of the criminal policy adopted from time to time by that section of the community who are powerful and astute, and they ensure that they safeguard their interest and comfort, and they ensure that this is done by the sovereign power in their interest. In India, we find that the essential code which deals with crimes is, of course, the Indian Penal Code. But then there are other modern statutory measures that have been brought into place where different other kinds of crimes have been defined and punishments have been prescribed for them. Be it in India or elsewhere, what we find is that the state, with all its might, takes over the prosecution. And since the state plays the role of the prosecutor, we require that the standards that are to be achieved are different from the civil trial, and the standard being that the case has to be proved beyond all reasonable doubts. It is in this process that we need to see what different functionaries have to play as a role for themselves. This includes the police, the prosecutor, the magistrate, the courts, and the defense counsel, to mention the important ones. Of course, reference would also have to be made to the witnesses, the correctional persons, the prison administration, and other participants who may have a role to play in this administration. When we look at the definitional function relating to a crime, we must realize that no one must be subjected to a criminal punishment except for conduct, and there has to be an appropriate law before anybody is hauled up for having committed a wrong. Now, this particular role is primarily given to the legislature, and in criminal law, if at all there is any ambiguity, the role that is to be played by anybody else, including the judiciary, is minimal. And for making these prescriptions material, the definition must be precise, and there should be very little room for any arbitrary application. And that is why these functionaries are expected to perform their respective roles according to the competence that have been allocated to them. If we start with the police, they essentially play two primary roles. One is the maintenance of law and order. The other is investigating an alleged crime. If you look at the constitutional scheme, we find that the police has been brought under the state subject, list 2, 7th schedule, which means that it has its confines to a state. But then there could be special police forces which have their jurisdiction which may go beyond a state. This particular police is a force that comes within the executive control of the government, and as such is supposed to be considered as an extension of the executive wing. Lately, there have been some suggestions to bring in some reforms in the police force, especially with regard to demarcating the roles that they play and assigning to them certain roles which are independent of the other. That is, the investigatory function to be performed by a distinct set of people who basically would not be given a law and order or security duty. This police is supposed to be a specialized investigating agency, and they are supposed to investigate on their own only when it relates to a cognizable offense. When it comes to other alleged acts as offenses, there are other procedural requirements that are to be complied with before the police starts investigating. As a part of investigation, there are different roles that the police has to play. They go to the scene of the crime, they gather information from the scene as well as from the witnesses. If necessary, they effect an arrest, they conduct search, they collect other evidences that are there. If there are incriminating materials, they do seize that. They record statements from those who seem to be acquainted with the facts of that particular situation. They get, wherever necessary, confessions and statements recorded by the magistrate, and after the investigation they file a report along with the draft charges that are there before the magistrate. And they also have other powers that are incidental to this power of investigation. As I mentioned earlier, the investigation is again considered to be an executive function and an executive power. And this power has been given as per the CRPC to what is called as the station house officer, the police officer who is in charge of a police station. This also imposes onerous duties on such a person. It must be noted that while the police investigate into an alleged offense, a magistrate is always kept in the picture, but then he is not authorized to interfere with the actual investigation or to direct the police as to how an investigation is to be conducted. To that extent, the police are supposed to be independent of the magistrate. The next category of functionaries would be the prosecutors, and we have the district prosecution system. The police and the prosecutors essentially are functioning in the same direction. However, the roles as such are less clearly demarcated. You find that the prosecutors at the lower court level are supposed to be functioning at a dual level. One, they must help the police collect the best evidence and also organize the best proof. But at the other end, you have the prosecutor who is supposed to be performing a public justice function to ensure fair, impartial and quality justice. Sometimes this seems to be at odds. The prosecutorial function has undergone a change with the introduction of Section 25 capital A to the CRPC, which brought in powers to the state governments to come up with a directorate of prosecution and a hierarchy of officers under that. This was done to encourage coordination between the police and the prosecution. Now, it must be understood that the law envisages a fair degree of independence and autonomy for the public prosecutors. But then, in actual practice, whether a prosecutor actually plays such a defining role is something which is to be doubted. Under the code, we find that there are public prosecutors, additional public prosecutors, and assistant public prosecutors envisaged apart from the special public prosecutors. They are supposed to be the counsels of the state, they are supposed to be representing the society in a criminal trial, and that's why they are not supposed to appear on behalf of the accused. And what you have to say as their essential role is to ensure that they have a duty to ensure not just conviction at all costs, but ensuring that justice is done. And that is why, as far as prosecutors are concerned, we may even impose on them a duty that wherever evidence is available with them, which may be in favor of the accused, we impose a duty on them to leave it to the court to decide what should be done with such an evidence, rather than keeping the evidence away from the court. The object of the criminal trial is to find out the truth, and the prosecutor is supposed to function in that direction. And it is in this finding of truth that we come to the question of guilt or innocence of the accused. When we look at the courts as the functionaries of crime adjudication, we find that the courts are envisaged both under the Constitution as well as under the statute, the Code of Criminal Procedure. The Constitution refers to the Supreme Court, the High Court, and subordinate courts. And Constitution speaks about certain jurisdictions that they have in these contexts. When it comes to the Supreme Court, we have the writ, appellate, advisory, as well as reference jurisdiction. It may also be remembered that whatever is said by the Supreme Court happens to be the law of the land under Article 141. And then when you come to the High Courts, their jurisdiction seems to be wider, even wider than the Supreme Court. A case in point would be what is provided under a comparison between Article 226 jurisdiction and the jurisdiction under Article 32. And that is why when it comes to the High Courts, we find that the jurisdictions range between writ, trial, appellate, reference, revisional, review, inherent powers that the High Court has, as well as supervisory jurisdiction that the High Court has. As said earlier, the Constitution also makes a reference to the subordinate courts. Then we have, on the other hand, courts that are dealt with by the Code of Criminal Procedure. The Code of Criminal Procedure basically divides the territorial jurisdiction into districts and sessions division. And as far as large cities are concerned, they may even be declared as metropolitan areas with their own structure of courts, metropolitan magistrates. In a purely adversarial system, we would say that the prosecutor and the accused are a sort of contestants who are trying to ensure that the truth would emerge from the effective constant challenges that they throw at each other. If you're looking at it as a pure adversarial system, probably what the judge has to do is to work as an umpire between the contestants. But it must be kept in mind that in the peculiar Indian context, the judge is not to remain as a passive umpire. Instead, he is supposed to be playing a more positive role, an active role for protecting the public as well as the individual interests of the accused persons. And the fact that this active role is envisaged is clear from the role that they have to play. They play a defining role in terms of charging the accused, in terms of having a say in withdrawing of the cases, prosecution, in terms of compounding of certain serious offences, in terms of having the power to examine any person as a witness, having a person to explain, if he is an accused, matters regarding the trial, and also the discretion as to accept the plea of guilty. It's not just a role of an umpire there that we are looking at. The courts in the system are supposed to be independent and impartial, and that is necessary for a fair administration of justice. And when we talk about independence and impartiality, we obviously start with the separation of judiciary from the executive, the requirement of open courts, the requirement that the judge or the magistrate must not be personally interested in the case, and also the requirement that wherever any small doubt arises as regards the independence or impartiality, there is provision for transfer of cases. If you look at the code prescribes 4 different types of trials: trial before a court of sessions, trial of warrant cases, trial of summons cases, and summary trials. Now, you must realize that the jurisdiction to try a case is different from the jurisdiction to take cognizance, and that is why it is said that a court may have the power to try a case, but not the power to take cognizance of the offence. And on the other hand, you may have a magistrate who has the power to take the cognizance of an offence, but will not have the jurisdiction to try that case. Cognizance and power to try are 2 different components of trial. When we look at the code, apart from the High Court, each state is supposed to have courts of sessions, judicial magistrate of first class. In the metropolitan area, we talk in terms of metropolitan magistrates. Then we have judicial magistrates of second class, and of course executive magistrates. There are also some other courts that are set up under some special legislation. For example, you have the boards that are constituted under Juvenile Justice Act. You may have some dispute resolving bodies that are created under the Panchayati Raj Act, or you may have some special courts that are set up to deal with certain kinds of disputes. When we come to the jurisdiction in terms of sentences that may be passed by a court, we find that the High Court can pass any sentence authorized by law. When it comes to the sessions judge or the additional sessions judge, he can pass any sentence, but then if he sentences a person to death, it is subject to confirmation by the High Court. As far as assistant sessions judge is concerned, he can go to the maximum of 10 years. Chief judicial magistrates have it up to 7 years. First class magistrates or metropolitan magistrates can go up to 3 years, and a fine which cannot exceed 5,000. And you have magistrates of second class who have the power to go to a term of 1 year and a smaller fine. When we go to the post conviction stage, we find that there are functionaries relating to correctional justice, and this correctional justice is in prisons or other institutions. They are covered by central and state enactments relating to that area. Those are Prisons Act as well as Prisoners Act. And wherever you are resorting to a structure, correctional structure other than imprisonment, we have the Probation Offenders Act of 1958, which deals with probation and different ways in which a person being put under probation can be dealt with. This particular functionary comes within the executive wing of the state. They are supposed to be executing, suspending, remitting or commuting a sentence imposed by a judicial magistrate. Now, this executive function and the executive power has been given because sentencing or until sentencing is a judicial process. But then post sentencing, we may find that there are circumstances where the particular sentence may look unjust, and that is why a need to revisit the same may be made out, and that is where you find that the executive wing have the orders of suspending or remitting a sentence. But then this does not interfere with the orders of conviction that must be remembered. It only affects the execution of the sentence. As mentioned earlier, when it comes to juveniles, a totally different scheme is envisaged. We have the Juvenile Justice Care and Protection of Children Act of 2000, which lays out the scheme when it comes to juvenile justice. The presumption of innocence that we spoke of earlier has a totally different connotation when it comes to juveniles. The juveniles who are supposed to be in conflict with law, we got to be cautious about the words that we are using when it comes to juveniles. These juveniles who are in conflict are in need of rehabilitation and restoration, not retribution. Similarly, the identity of these persons, if disclosed, may affect their rehabilitation, and that is why we have provisions including the ones which impose a fine on anybody who discloses their identity. The institutionalization of a juvenile is to be the last resort, and the detention, if at all prescribed, cannot go beyond 3 years. The statutory provision in the JJ Act ensures that no stigma is attached to any such juvenile in conflict with law. We do find that there are reports, social investigation reports, background reports that are to be made by the probation officer, which is supposed to go before the Juvenile Justice Board as and when it considers a juvenile coming within the scheme. The juvenile is supposed to be given a bail as a matter of right and can be denied the same only on exceptional circumstances. The Act also speaks about setting up of special places like the observation homes, special homes, places of safety, and these are set up not under the correctional department of the government but under the women and child development department of the state governments. The juvenile justice boards are supposed to set up in every district, and those who are on the board are supposed to be those who are trained in psychology and child welfare. We also have the requirement that every police station must have a special juvenile police unit, as well as the fact that a child welfare officer must be designated to all police stations as a requirement. The next category that we are dealing with in terms of functionaries is what is called as the defense counsel. Though this is considered as a requirement of fair trial, and you find that the Constitution itself envisages the position of a defense counsel, a person who is otherwise unable to find a counsel for himself sometimes finds himself at the mercy of the system to provide him with a counsel. And that is why we find that this particular right which a particular person who is accused of an offense is supposed to enjoy must be enjoyed in its full and in a meaningful manner, even where the state is providing a counsel for him. It must be understood that this right of his is supposed to start at the stage of the arrest itself. We have had instances where the code as such did not refer to that, and we had the Supreme Court, Honorable Supreme Court coming in and giving directions, and we see that some provisions have been added on to the code later on, which have basically given statutory provisions to many of the directions that have been given by the Apex Court. These defense counsels are also supposed to be the officers of the court, and of course, as I mentioned earlier, their role is a must when it comes to an adversarial system. The constitutional duty of a state to provide free legal aid is there in order to ensure that equal opportunities for securing justice are not denied to anyone, especially a person with any economic or other disability. What we have to ensure that is that the schemes that are in place ensures that the person gets an effective and free legal aid. The legal aid functionaries may be drawn from very many other areas, including advocates from the private practice. You may have student legal aid clinics that are there, and of course, one of the very vibrant areas are the NGOs whose capacity can be tapped for the purpose of ensuring that the particular object of ensuring a fair justice is ensured. To summarize, what we have been looking at are the different functionaries who are involved in the criminal justice administration process. We saw that the process starts with the initiation of proceedings, probably by an information to the police or by some other means by which the investigation starts. The police plays a role. There are different powers that the police has. And then you find that the prosecutor comes in and takes the matter forward once the final report has been filed and the matter reaches the court. Right from the beginning, you see that the magistrate is kept in the picture. And then you find that the magistrate has, or the court for that matter, has certain powers during the investigation, and then once the trial starts, we have jurisdictions determined by way of the heinousness of the offense that the person is charged with. And then you find that post conviction and sentence, other functionaries come into the picture, especially the correctional system functionaries. The correctional system functionaries, as we discussed, come within there are references to that in the code as well as the other statutes which deal with that. And as far as correctional functionaries are concerned, it's not just imprisonment that we are looking at, but in terms of other methods of correction which excludes imprisonment, more importantly the one that deals with probation. We also saw how the system takes a totally different call when it comes to juveniles, both in terms of the procedure that is to be involved and as to the results that the juveniles would be put to, if at all they are found to be in conflict with law. We also made a mention of how you have certain powers that are given to the executive wing of the government under the CRPC for the purpose of ensuring that offences, the cognizable ones, are prevented. This basically tells us what these functionaries are supposed to play as their respective roles, because their playing that role assigned to them is the most important thing to ensure that the system has a fair way of dealing with criminal justice administration, which is a must in a society which has its roots in the rule of law. Thank you.